So, sexual harassment at the workplace is a huge problem. Recently, an interesting order came from the Supreme Court where it was said that the complaint that was filed it could not be taken on record due to some technical reasons, but it should be part of the CV of that particular professor who was accused of sexual misconduct. Your thoughts on the matter?
So, firstly, if you see the Sexual Harassment at Workplaces Act, to have an extended period of limitation which cannot be extended, in my view, is completely, illegal, and it should be declared as ultra virus. Because in any work environment, just imagine a lady going for work. She goes to work out of necessity, or she goes to work because she also wants to be a earning member of the family. She also works because she wants to secure her future. She doesn't want to be dependent on anybody. Now, while at work, if something happens to her, the choice for a lady to make a complaint, a written complaint for the purposes of limitation is as good as resigning from the job. So, the lady most of the time suffers the harassment thinking that it may not get worse, it may only stop at this, I have ticked him off this time, next time it will not happen. But if things keep going wrong again and again, or if the incident keeps haunting her for some time, and she feels that no, she should not have subdued at that point of time, or she should not have compromised her dignity, then because of this limitation for her to not be able to make a complaint, according to me, is completely ultra virus. The very purpose for which this act was brought in. Secondly, in that particular case, I personally feel that even if the Sexual Harassment Act could not be invoked, there were clearly IPC sections also involved. If I go by the old IPC 354A would apply, and even under the new IPC section 75 will apply, where even if there is limitation, there is power to condone. So I don't see, at least a case should have been registered under the criminal laws for this kind of harassment, even if the court felt that the sexual harassment complaint under that particular act cannot proceed. But at least the IPC offences could have been set in motion and a complaint could have been made, even if the girl had not made a complaint herself. If the matter had reached the Supreme Court, the Supreme Court could definitely have directed the magistrate to register a case, or the police to register a case if it is cognizable, and investigate the case so that the matter goes to its logical end, rather than saying that the girl is now a helpless victim, and by virtue of this limitation, she cannot be, given any justice.
So, in these cases where the limitation applies, say to lodge a complaint internally, is it possible that a complaint can perhaps be registered with the police authorities? Because there is no limitation that applies there.
No, even in a police complaint, if it is, if the offence is below a particular period, then there is a period of limitation under the CRPC, but that limitation can be waived. There is a power to always waive that limitation. So, under the IPC or this new act which has come in replacing the IPC, definitely case could have been registered by a victim against the perpetrator.